Therefore, agree with me. Yes. You agree with that or not agree? I agree. You would therefore agree with me that when you bump the first motor vehicle towards the second motor vehicle, the motor vehicle that you were driving was damaged. I can agree with that. You also agree with me that the object you used, you knew that it has a potential of killing someone, especially when using it several times. Yes. Yes, yes, I agree because I hear many people that accuse you use a knife being used. And you also agree with me that a knife can kill someone if you step on. But you are not going to see what you are going to. Yes, I agree. No further question.
Yes, actually, there's evidence before court by Ms. Ndoli that after parking weights on queue in town, they reported to my duty to inquire about the protection order that I was supposed to have been served by the police on me.
What are you, who are you doing? You are in our two of I never thought about it. I would have put this car professional or anything there. You can really do it. You will.
So the question that I have now is, were you aware that there is no protection order against you?
I don't know. You don't think how we know, not position or anything. No, I didn't know because if I knew, I would come. I would be the same closer.
There's also evidence that the previous day you threatened on the deceased, threatened.
Like what? What was single fifty. We don't do the level of moral. Not evidence.
Evidence by
But look at the one that you do. There's that police station that's really is one who wanted to fix our issue and one is one who arrived and said I should go. When we were in Dallas.
you might have heard that when she was saying that you threatened to kill the deceased more than once.
The wrong we are about. Otherwise, we hear about to say that all the lie and this is no, I don't report.
You don't recall what is the way that you recall?
You
You don't recall hearing when we were saying that, or you don't recall uttering those words or those threats.
awukuli ukalele abona kaba awukuli wena uthuzela umuntu wakula izo lekuli indlela yakho that's like person disease so it's like person disease
So you don't remember threatening.
awukuli uthuzela
So this is how seeking something so that
the other stated that I admit all that I did, but now it should not be said that everything that I did there, I did to the people.
So it is your evidence then said that you went to the area C with your friend. Said this, all right?
He was about when that was yes,
And then in the morning you got your friend took you to Miss Tony's home. Is that correct?
because all the money come menu. Yes,
So what we said it was just before 8 when you arrived at Miss Tony's place.
the only money come menu within a week. This is a week.
so
Yes, for sure.
So you might have heard Miss Yoli saying that indeed she was in company of the deceased when they went to her home.
You feel when I would have come and feel about the half. Every moment.
Second place,
One
where
time,
the incident occurred.
one of which I really
in his moon is sort of made up
yes, because
So you went there because of the appointment you had with the deceased.
We never had one appointment. Yes.
And you saying that it was before 8, it was early in the morning.
How many people eat? Even to say, yes, because that's the only thing.
So just help me here, Mr. I'm sorry to understand the logic behind you carrying the knife, visiting your girlfriend as the appointment. Why did you have a knife? Why were you carrying it?
I will be the morning. More of second one, go on there. That is why we want to see but we have to appointment. You go on there. I don't take the knife. I take the knife because I don't have a firearm. So I always protect myself with the knife. Because I mean, there are also criminals. It's nice. And someone likes me. It's nice.
Is your home, Mr. Khitleli, in that locality where the deceased was killed?
Java, I, you want to know no, it's not the distance, but close to there.
Alright, so you woke up in the area, see, you drove to this locality.
So,
To meet your girlfriend.
why am I in that you know, go on? You are there. Yes, yes, that's the time that was arranged. So I was ready for any time because I was wanted to.
So you agreed to meet before 8.
I'm going yes, they said they school later. They all go to school when no one starts school time.
So the deceased agreed on the appointment with you during school hours because the same thing was just before 8. That is the time when the school is supposed to start.
Mfuyelo bakubera ukubane iyi takara school wala na kuya yawo ya ukitila kule bamfulu traditional yes they agreed and in that time I was given by them they told me that the school there is something that is happening in school so they want to go to school in the normal time.
Do you remember that the issue of the appointment was put to Lady? And she really denied or disputed that there was such an arrangement between the two.
Wakula ule kuya apel mtaka waina aikili ya ule noti ni appointment ni nani wanaweza
Yes.
na mtu ajia yes I did it disputing that but she was asked disputing it because she was not because
So if you include them with me, why would she, because you saying that I'm her alien.
yes to because to suppress me.
Okay. So if you're in good terms with me, and you should be one who was trying to fix the relationship between the two of that is the why would she then have a life? Why would she then come to court and suppress it?
Aiwa uwe mtu mlikuwa na ili wani dala kulikuwa kile au hali nzuri because maybe I think because I was going to lose a friend and I ended up saving him.
Last thing is education. And let's go to image 15. I see where you placed a mark that is X, and I think it was agreed that it is S between the platform from the car to the deceased was about 2 meters, 2 meters, right?
Şimdi orada doğru Dewan berani uyuyin eksma. Oraya mela durma bulava bicara ya.
So it is saying that the stabbing occurred inside the car. Then how come then the deceased was 2 meters away from the car?
Ayo uli, tetapi kita kan uli. Orang dari nanti bicara tadi, coba uli.
Saya apa isu yang itu boleh yang kita akan kita harus sekarang sebagai sekarang ini.
Tetapi jangan tetapi kita that during the vehicle, then I tried to run away, and she also opened the door. And I like to
It was stationary.
he can't be here.
I mean, it was stated she tried to run away.
Sudah begini saat tadi kau balik.
Oleh yang bisa kita yang kalau susah ini yang ini mau bilang sama hasil itu polisi bisa
And that police stated that he was getting the vehicle. Then there was this commotion between us. She tried to open the door. I tried so that I can run away.
So you
Run away using the vehicle.
you tried to pull her back inside the car or you pull her outside?
That is how we feel. Everybody got one street.
kita
She wanted to get out of it.
And then,
so after that kita mau bilang tinggal terus saya pasti kita mau bersama sebelum
That's when I went to the driver's seat and tried to help her because I could see that she was losing out.
I don't think I hear what you're saying.
I didn't want to get into
Or maybe if you can just give us a picture. Where were you seated? Were you seated in the passenger seat, front passenger seat, or?
I was just trying to say, you know, sitting, say something, say something. Front passenger seat.
And where was it seated?
Yeah, no, that was
Can you then try and make this distance?
That will
It's
be-
2 meters between the deceased and the motor vehicle.
Aku ini kira ya itu bahan, misalnya semua. Nanti jika ada di kita mau beli itu.
At one stage, in fact, you started. Why was she still inside the car when you started, or you continued standing there even when she was outside? You tried to run away?
Kemudian dia mau beli. Tak, dia orang tu lagi mau. Tak, kan ada yang saya mau beli.
saya mau menjadi transaksi soal masalah
Right?
masalah bunga sebenarnya ini kita mau
When she was outside the vehicle, that's when now I was scared that I was trying to leave the house.
What I want you to understand, or what I want to know is that it is just simple. If it is every okay inside the car, if yes, then how come then the deceased was about 2 meters from the car?
Jadi pada mungkin kamu puri, bukan kita alina, tapi ayo bukan kita al, bukan orang orang itu. Ada di bicara sendiri, kamu puri ini.
hanya kita asal kan mau bisa jadi ada hasil kita boleh yang di sana itu kita mau
When She was now outside. That's when I went out and tried to get out, and I pulled a bit so that I can get out of it.
How did she get out of the car? Or in what age did she actually get out of the car?
You don't want to read. That is easy. We don't kill people.
You know, housing.
Yes, I was sitting. I think that time she went out of it.
So the justice was a teacher you scared her, right? Or they say the first statement saying that she was innocent, right? Then what happened?
The first one from that was, tomorrow I'm certain that I will find her.
It was and the mother and that movie as well. After this fight, you know, the people were
She tried to get out of the vehicle. When I saw that she's out of the vehicle and she did that, that's when I started.
Did she try or she actually got out from her?
So that when we were about it, we
when I was out and
she got out of the car, and she fell just near the vehicle.
Yes, and then you pulled her.
after immediately entering the secretary, I went to take
She arrived immediately after the incident happened. She was coming out of the house. She arrived the time I was trying to wake her up.
All right, and then you left her lying there and advanced to leave.
Wamusia after
kill the deceased.
bopaki ba mmetong ke wena o je ba tshabisa ka go tla go bolaya
You said, I'll kill you.
wa tla bolaya
Did that ever happen? Did it happen?
ile e tla lapeng
she is like, check out my naked together.
ile e tla lapeng no it didn't happen.
That's all.
Thank you, Mr. Hakiti.
Ya go dira mane
Look. Colleagues, are you ready with your arguments?
Your worship, that would be the case for the defense.
Come again.
That's, I'm closing my case.
Oh, all right. So, okay, defense case closed. Are you ready with your arguments, colleagues?
Just a moment, please.
Mr. Napier, are you ready?
Your worship, I'm ready, but I'll request a postponement. There are some issues that I need to research.
Okay.
If Mr. Normandy is ready, we can proceed to this. I'll see if I need to go through that research.
I think it's only fair that we proceed. If Mr. Napier is not ready, I don't see why Mr. Nomadi can proceed with his argument.
Indeed, so worship. We may just postpone the matter also for arguments. Yeah,
Can you agree on this? So this year is off now. You are already closed. The office is already closed, Mr. Nicky.
Closed, Your Worship, unless you set it down.
So there's no way that we can come back on Monday.
Christmas Day.
No.
We are closed as from one.
Just from 100 hours. Listen, you said you are coming back on the 16th.
The recess, Your Worship, ends on the 16th.
On the 16th.
However, on my part,
Mm.
there's a high possibility, Your Worship, that I might be doing Islam.
You might be doing
Islam,
when?
China. However, Your Worship, I'll have to.
Maybe we should just proceed with the argument. It's going to be a lengthy discussion.
You may be seated, Mr. Secretary. So what are you saying, Mr. Secretary?
Now, if it's going to be a lengthy postponement, I will manage and I will argue. I will argue.
Today. So,
The state is there.
yes.
Thank you, Chief Justice. The accused person is facing 5 counts. The one being murder, Your Worship, count number 1. The state, Your Worship, will be dealing with that count as its point of departure. Your Worship, the state humbly submits before court that the accused person does not dispute having killed the deceased, unlawfully so. That, Your Worship, is evident on the accused person's 220 admissions. However, Your Worship, what is in dispute in respect of that count is the part of premeditation. Your Worship, the state humbly submits that even if all the evidence prior to the killing of the deceased person would be disregarded by this honorable court, premeditation, Your Worship, has been proven by the state during the commission of the act of the offense. Your Worship, the accused person does not dispute having stabbed the deceased several times with a knife, something which he knew is dangerous, and used it to protect himself against firearms if it needed be. Your Worship, on the disputed part of the charge, the state invites this honorable court to the case of Aliko versus State, ALIKO, case number 552 of 2018, a decision, Your Worship, that was handed down by the South African Supreme Court of Appeal in 2019 on the 28th day of March 2019, Your Worship. Your Worship, in that case, Your Worship, at paragraph 37, when the court was referring to the case of State versus Kekan, a 2014 decision in the same court,
You said paragraph
37,
37.
it was held, Your Worship, in that case, that premeditation does not necessarily entail that an accused should have thought or planned his actions for a long period of time in advance before carrying out his plan. This is because even a few minutes are enough to carry out premeditation. State humbly submits, Your Worship, that during the time when the accused person was stabbing the deceased, he was carrying out his premeditation to kill the deceased. On the second count, Your Worship, that of attempted murder, all elements have been admitted by the accused person. And it was in accordance with the state's case. On the count, Your Worship, of theft of motor vehicle, the state, Your Worship, submits, albeit the accused person's plea explanation of not guilty, Your Worship, that he had no intention to permanently deprive the deceased of a motor vehicle. Your Worship, the actions of the accused person during the taking of the motor vehicle infer one thing and one thing only: to permanently deprive the deceased of a motor vehicle or the lawful owner subsequent to the deceased, Your Worship. In his testimony during evidence in chief and confirmed under cross-examination, he took the motor vehicle to go and commit suicide with the motor vehicle. How then would the owner of the motor vehicle have gotten the motor vehicle back from the accused person, someone who took the motor vehicle without authority? Your Worship, state humbly submits before this court that even if, Your Worship, it were to be argued that the motor vehicle was recovered, or at some stage he would have brought back the motor vehicle, Your Worship, the state is of the view that theft occurs, Your Worship, by appropriating and exercising control over one's property without authority the minute you take that property, as theft is a continuing crime. On the count, Your Worship, of reckless driving, to be specific, the state, Your Worship, did not make any paragraph or full submissions to that aspect, because the accused person admits to that count. He was driving the motor vehicle without considering other road users, as he says so in his evidence and also in his 220 admission. He knew, Your Worship, that the motor vehicle he was driving was in fact bumping into other persons' motor vehicles, and he did not have any regard to those persons. The state submits this, Your Worship, even though it was not elicited from any evidence, but for the photo album, specifically photograph number 30, when the motor vehicle was recovered from the accused person. In that picture, worship, there is no depiction of any other motor vehicle besides that one and the one behind it at a distance. The state, your worship, submits that this accused person, when he bumped over more than one motor vehicle prior to the recovery of the motor vehicle at photograph 30, he did not consider any of the road user. On the fifth, your worship, and final count, the accused person, your worship, under cross-examination by the state, he concedes that when he drove the motor vehicle until it was recovered, he knew that it was damaged. He did not stop on his own volition. As he says, he was stopped by the police. State submits, your worship, that the malice in the damage of the motor vehicle was in the accused person's minds at the time. In those submissions, your worship, the state prays that this honorable court finds the accused person guilty as charged in all counts, your worship, and in count number 1 be found guilty as charged as per section 51 subsection 1 of Act 105 of 1997. Those are the submissions, your worship, by the state.
Yes.
Thank you, Your Worship. I will start with the count of reckless driving. The accused did plead guilty to that count. And I think was found guilty on that count. Count
Count
4. Count 4. He had pleaded guilty to that count. As far as count 5 is concerned, it's my submission that the state has not proved its case beyond the reasonable doubt. It's not proved that my client had malicious intent to damage the motor vehicle. Yeah, Your Worship, we dealing with what you would call the fight or flight issue. If one looks at the evidence in its total, my client's evidence that he fled from the scene is not was beyond a reasonable doubt. He stabbed the deceased, he realized what he had done, and he decided to flee. His reason, he says, for using the motor vehicle is that he wants to commit suicide. So it was never his intent to deliberately damage the motor vehicle. If one looks at his evidence, then his intent was to commit suicide, nothing to do with damaging the motor vehicle. One malicious injury to property. The elements there is that you must have the intent to harm the person through his property, the way I understand it, Joseph. So there's never that intent. Even if one takes the state's argument that he knew that the deceased had died, there could never be a malicious intent to injure the deceased person in a property. There's no reason for him to have formulated that intention when he knew that the deceased has passed away. So merely to say that he knew that the vehicle was damaged doesn't prove intent, that he intended to cause this damage to the vehicle, to injure the complainant. So on that count, I would ask that my client be acquitted on that count. Sorry, you should count 5 to be more specific. Just on that, Joseph, that count is, and I'll ask the court to guard against this. It could be, my submission is a duplication of charges on the reckless driving. It's either that he was driving reckless, he didn't necessarily have the intent to damage the vehicle, but because of him entering into a flight mode, fleeing from the scene, he did not care what happened, whether he damaged the vehicle or not. And on that, it's not, I mean, it's common today that a person kills someone, then they decide they can kill themselves. He is evidence that the manner he chose to kill himself was to maybe smash into another vehicle. It does happen where people deliberately drive into other vehicles to kill themselves. There's many ways of committing suicide. So his story or his version is not far-fetched on that aspect as well. The court would bear with me. I'm just looking at the counts. That's in respect of count 5. Count 4, he has pleaded guilty to that count. Count 3, Your Worship, the theft of the motor vehicle. My submission that the state has not proved that count beyond a reasonable doubt as well. Mainly because of the contention that I've made, Your Worship, that my client entered into a flight. Can never be said that he had the intent to steal the vehicle or to fulfill that other element to which he pleaded not guilty, or which he mentioned in his plea that he had the intention to permanently deprive the complainant of the vehicle, Your Worship. That was never his intention, or the state hasn't proved that that was his intention. Mainly because, one, he did not, although the state has mentioned it's a continuous offense, but he did not get away with the vehicle. It's my submission that for the state to prove that he had the intention to permanently deprive the complainant of the vehicle, you'd have had to actually succeed with the taking of the vehicle and then keeping the vehicle. So this, you cannot, from the evidence before the court, one cannot really conclude what the intention of my client was. For that to be inferred, you would have had to have succeeded in taking the vehicle and succeeded in his flight, gone somewhere and kept the vehicle until the police recovered the vehicle. Yeah, it was an attempt which had not advanced to the stage where one can say that this was his intention, to permanently, that is to permanently deprive the complainant of the motor vehicle. As far as the murder, Your Worship, it's common cause, and my client in that regard has admitted that he caused the death of the deceased. So the only issue there is, my submission, is whether he had planned this or whether it was premeditated. Although the Section 220 says that the deceased was stabbed several times, Your Worship, it would seem that, well, several times is that she was stabbed, possibly twice or thrice. With only one stab being fatal, Your Worship. That's the stab that to the chest that penetrated the heart and lung that caused the death of the deceased. The second stab, one cannot say whether it was twice or thrice. Okay, I see it was 3 times, Your Worship. There was a stab on top of the head, or a laceration on top of the head as well. No, I'm looking at the wrong. I'm looking at, sorry, Your Worship, that Tony's. By respect to the deceased, Your Worship, it's my submission that there's only 2 stab wounds. The one on the chest where she was stabbed on the chest, into the heart and the lung. And then there's a laceration on the right arm and a wound on the ear. So as far as the arm and the ear are concerned, one would not, even if the doctor was called, one would not be able to say whether it was inflicted by one stab or two stabs. She could have been trying to defend herself, and that's how she got stabbed in the arm and in the right arm and the right ear. But on the facts, it would seem, if one looks at the post-mortem report, the finding is that she was stabbed 3 times, with one wound being fatal. The state has referred to the case of Aleko versus the state. It only takes a few minutes. Few minutes are enough to conclude that there was premeditation. But, Your Worship, the court will have to look at the facts of the case. We do not know what the facts were. It's easy to say that the court concluded that in that case, but without the facts, it doesn't help, because there are circumstances where it can't be concluded that a person within a few seconds or few minutes created this premeditation or planned the murder. But in this case, the facts are different, Your Worship. We only have my client's version as to what happened there when immediately prior to the stabbing. When Ntoni came out, the stabbing was happening or already had happened. So if one looks at the facts immediately prior to the stabbing of the deceased, it's my submission that the court will be able to draw inferences as to what exactly happened prior to the stabbing of the deceased, and whether my client actually formulated the intention to kill the deceased. If one looks at that part of the evidence holistically, there's nothing to infer that it was planned. He says it was an argument. He stabbed her in the heat of that argument. From the surrounding circumstances, there's nothing to detract from what he's saying. On that, if one looks at that specific incident or those moments, did he have the plan to kill the complainant in count 2? Or did it just also happen on the spur of the moment? he was in this state where if anybody approached him, he would stab them without necessarily planning or premeditating to stab them. It was just on the spur of the moment, that instant violation to stab the complainant in count two. One cannot say that there was premeditation here on count two as well as on count one. There is the evidence of what happened the previous day where, well, came across, and if one accepts the state's case, that he was stalking the complainant or interfering with the complainant, but that does not necessarily mean that he had the intention or that he planned to kill the complainant. But this is, if he had that, you could have killed her on that very same day. Even if one accepts that the evidence of Tony that he threatened the deceased, it's not always that these threats are carried out. One can say, I'll kill you, but it doesn't necessarily mean that you have the necessary intention to kill the person. It's my submission that on count one, the state has not proved beyond a reasonable doubt that my client planned or that the murder was premeditated. The court has to look at the facts of this case, and on the facts of this case, it's my submission that there is no evidence that he planned it or that the murder was committed with premeditation. His version that he is always in possession of a knife, he uses a knife for self-protection. It is reasonably possibly true and not false beyond a reasonable doubt. And in any event, the law is that the court must take each case on its own circumstances. One cannot say because it was rolling a leco that it takes a few seconds. One has to have knowledge of what the facts were there for one to conclude that there was premeditation. We do not know those facts. And in this case, the facts point to that one cannot infer, at least one cannot infer from these facts that there was premeditation on behalf of my client when he killed the deceased. For that, what would have assisted the state with that aspect is if they had called those eyewitnesses and those eyewitnesses dispute my client's version as to what exactly happened or what led up to the stabbing of the deceased at that time. Your Worship, if I can also, in the case of S versus Makatu, it's 2006, Volume 2.
So it's businesses.
Makatu, Makatu. It's a 2006 decision, Volume 2, SACR 582, Supreme Court of Appeal. Your Worship, the facts in that case was that, if I recorded them correctly, that the appellant had taken a firearm with the intention of shooting his wife. And he actually killed his wife. He went with the firearm. It's sort of similar to what happened here. But at the end of the day, it was ruled that there was no premeditation. He went with his unlicensed firearm and shot the wife. The motivation was that he was losing his share of the estate, but there it was ruled that even in those circumstances, there was no premeditation. So in this case, even if my client's version that he always carries a knife is not accepted as being reasonably possibly true or false beyond a reasonable doubt, then it does not necessarily mean that because he had the knife that he intended killing the deceased. And it was ruled that, as I've mentioned and following on this case, Your Worship, that the court has to determine premeditation by inferential reasoning. That would be the only way the court can come to a conclusion, because, well, in this case as well, where there's no actual eyewitnesses as to say what happened outside the house before the deceased was stabbed. So the direction that case gives is that the court must interrogate the facts on each case and then deduce from that whether the commission of the offense was premeditated or not. So it's my submission that in this case, the facts do not support the fact that my client's actions were premeditated, and I apply that he be acquitted on the count 1 of premeditated murder and were found guilty on murder as pleaded. I think that takes care of all 5 counts.
Yes, because even with respect of count 2, he pleaded guilty.
He pleaded guilty. Those are my submission, unless there's anything else to talk.
Thank you.
None, Your Worship. It's 5 to 3.
Are you sure that they did not shake it? Who has the shake?
Yes, I heard.
Please, can you please check?
The next schedule is 1500 hours to 1720. Okay, so expected resolution. Yes.
Let's see. Hopefully, maybe there's a change of the stage. But I think the accused person is listed immediately to appear before the court.
Is that the second?
Yes, to appear before this court, facing the following charges. The first account is made in that on or about the 23rd of October 2020 at Onion Second location the accused did unintentionally kill Mukharan woman, a 26-year-old female person by stabbing her with a knife. And the subsection 51, subsection 1 is applicable in this offense. That means it was premeditated.
Mokusua. Italia Hutalena Hidatuaga, Mokusua, usaile pila Hutalin, Ashevali Kusotestan, Kusoyapi, Iling Yapulao, 8 October, Simon 2020. Mokusua went to Gabu, the Ganjo Tuga Abulaya, Hawan Makumani. Kusoeu, Muso, Hamubay or Kusoel, Guido Habulena, Une Aikebisi Kapa, Une Arabia Mubulaya, the Fiona.
The second count is that of attempted murder in that on or about the 23rd of October 2020 at Union Sequence in the Regional Division of the Eastern Cape. He did unlawfully intentionally attempt to kill Ms. Relebo Hilendon, a female person, by stabbing her with a knife.
Uzoefu ashabaniliwa yake kwa kulala kutizama katika na mshaka 23 Oktoba kuile alika kulaya iliyotoni amshaka kati au yeta honu kachuka isanje kumba.
The third count is that of theft of motor vehicle in that on the same date, same place. The accused did unlawfully intentionally steal a brown Toyota Rush motor vehicle with registration letters and numbers NCW 23745 for the property or in the lawful possession of Winnie Makumani. Alternatively, unauthorized borrowing.
Kusaba ashabaniliwa ya mshumu baguruni kutikana na zile kuile auto kuruni aliyeta honu abata honu nayo aske api aifuma.
The fourth count is reckless driving. The same on the 23rd of October 2020 and on T12 road, which is a public road here in the Regional Division of the Eastern Cape, where the accused did wrongfully drive a motor vehicle to wit a Toyota Rush with registration numbers or letters and numbers NCW 23745 recklessly.
Uzoefu ya honu usuai kuile akhanna ambi lega usitoteli akhanna kurui esinya hayi.
And the fifth count is that of malicious damage to property in that on or about the 23rd of October 2020 at Onia T12 Road here in the Regional Division of the Eastern Cape, he did unlawfully intentionally damage a Toyota Rush, the property or in the lawful possession of Winnie Makumane with intent to injure or to damage, in fact, with intent to injure or damage her property.
Uzoefu ya mnata kurui elinya nema kumani ana ba ikemisetso a go ilematsa kapa go lematsa ena.
On the 25th of October 2022, the charges were formally put to the accused person.
Ka 25 tsa October selemong sa 2020 o ile a bolellwa diqoso a qoswang ka tsona moqosuwa enwa.
He pleaded guilty on count 2, which is attempted murder,
O ile a dumela molato wa teko ya polao
and also pleaded guilty in respect of count number 4, which is reckless driving.
a o dumela gape molato wa mone e le mo kganna a moithuti ka sehlopeng.
As per the pleas, in fact, section 1122 statement was prepared and read into record.
Polelo e ba o dumela melato eno ka yona e ile ya balwa lekgotleng.
And the state accepted the plea.
Mmuso wa amohela tumelo eno ya molao.
There were also admissions in terms of section 220 that were made by the gentleman before court, Mr. Khitleli, and they were admitted as Exhibit A.
Teng bopaki hape monga ditsi a ileng a fana ka bona ya ba bo ya amohela ke lekgotla.
In those section 220 admissions, he admitted that indeed on the 23rd of October 2020, he stabbed the deceased several times using a knife.
A dumela melato eo o itse ke nnete ka mohlala 23 October selemong sa 2020 o ile a hlaba mofu ka makgetlo a mangata a mo hlaba ka thipa.
And that the stabbing of the deceased with a knife caused injuries which resulted in her death.
Ebile o dumetse hore maqeba ano a entseng mofu a hlokang ke e bang a entseng ke ena a ba etsa ka thipa.
Then as Exhibit B, it is section 1122 statement,
Ho la ba teng bopaki bo bong ba polelo a e entseng moqosuwa enwa.
where he was pleading guilty, admitting all the allegations on the charges of attempted murder as well as reckless driving.
Moo dumela o ne a dumela diqoso tsa teko ya polao le tsa ho kganna hampe le ka ho se hlopheng.
The court will then start with the guilty plea.
Lekgotla lena le tla tlatsa le tsebang ho dumela molato o tsona.
It is common cause that Ms. Boitumelo was stabbed on the day in question.
Ke ntho e sa phedisweng ya hore Letona o ile a hlajwa ka letsatsi lena.
The medical report was admitted as Exhibit C,
Polelo ya ngaka e ile ya nkuwa ya amohelwa ke lekgotla lena.
and also the clinical findings were read into record.
Polelo eo e ile ya balwa lekgotleng mona.
There was a stab wound on the head, which was plus minus 3 centimeter laceration on the head,
Ho no le teng leqeba le teng mona hloohong,
stab wound on the chest.
leqeba le sefubeng ka ho hlaba.
I am trying to read this handwriting, but of course it is the doctor's handwriting. I'm struggling to see it. But it is clear that there were stab wounds that the doctor, when examining the lady in respect of count 2, that is Miss Ntoni, managed to find there's a 3 centimeter laceration on the head. There's about 2 centimeter laceration
Empa ho a
on the
hlaka hore
back,
ngaka e fumantshitse hore ho teng maqeba e bang a funyane ke Letona.
and other wounds 5 centimeter long that are on her back.
A mang maqeba a mona mokokotong.
And there's also another injury that is about plus minus 5 centimeter long or on the abdominal part of complainant.
Ke leqeba le leng hape le mona pakeng tsa theka le mona.
So this shows that indeed Ms. Ndoni sustained injuries as a result of the gentleman before court as per his guilty plea.
Ba hlaka he hore mme Ntoni o fumane timalo e entsweng usuwa eo a phela Afrika Borwa.
And the court is satisfied that indeed Mr. Khitleli is admitting all the allegations or all the elements in respect of count 2, which is attempted murder, and count 4, which is reckless driving. And he is found guilty as pleaded in respect of the two counts.
Le a kgotsofala hore moqosuwa eno o amohela tsohle tse bang qoswa ka tsona ke mmuso, e leng tshebetso ya polao le ho kganna hampe le ya ho se hlokomele, mme o fumanwa le molato diketsong.
Then we move on to murder. That is the
Ha e
first
le
count.
hampe hee, polaong.
So the accused person made it clear that he is not pleading guilty because the offense was not premeditated. That is according to him.
Moqosuwa o hlalositse hantle hore lebaka le etsang hore a se a o dumela molato ona wa bolaya ke hobane mmuso o ne a rerile ho bolaya motho eo.
So that is why he is pleading not guilty.
Ke lona lebaka le etsang hore a sa o dumela molato.
The state then had to lead the evidence of Ms. Ndoni, Relebohile Ndoni. You don't speak when I'm speaking, so just sit down. Just sit down, please. You may sit down, sir. Just sit down. Right, the state led the evidence of Ms. Ndoni, whose evidence is as follows. Indeed, on the 22nd of October 2020, she was together with the deceased person, as well as Ayabonga Mpono. It was after school when they went to town in a place called Dallas. As they were still eating their orders or the meat that they had ordered, the accused person arrived. On his arrival, he called the deceased person, and the deceased said to him that you have been, in fact, open quotes, you've been ordered to stay away from me. I have applied for protection order against you. The deceased then stood up and went to her car. The accused person then followed her and got in the car with her. Ms. Ndoni and Ayabonga could not hear what the two were saying as they were left behind. But they were able to The deceased then replied by saying that it is Boitumelo, that is the accused, who is insisting on speaking to her even though she does not want to.
o ile a re Boitumelo o batla go bua le yena ka gang a sa batle.
The accused then replied that he will speak to her because he has not received or had not received protection order at the time.
Mosuwa o itse o tla bua le yena gobane ka nako eo ga se o fumane protection order.
Ms. Ndoni told the accused to leave.
Mme ke o boleletse mosuwa hore a tsamaya.
He says that the accused person appeared cheeky and refused to leave.
Gore mosuwa o ile a bontshana le gang o ile a hana tsamaya.
Then other colleagues, that is the deputy principal, Ms. Ramabele, Ms. Mutsisa, and Mrs. Makada arrived.
Mme Ramabele le Mme Makada ke mo ba ile ba fihla.
That is when the accused left.
Ke moo re bang mosuwa o ile a tsamaya.
After some time, they proceeded to Nedbank.
Ka mora nakonyana ba ile ba tsamaya ka Nedbank.
From Nedbank, they went to Spa.
Ba tloha Nedbank ba ya Spar.
They met the accused again,
Ba kopana le mosuwa hape.
and he still wanted or insisted on speaking to the deceased.
O ile a nna a qobella hore a bue le mofu.
And the deceased did not respond.
Mofu ha a ka morara.
Accused then pulled her with a belt.
Ntse?
A belt, yes.
Mosuwa o ile a mo hula ka lebanta.
Saying, "Hey, you Mparwana, you do not want to speak to me. You no longer want me.
A re wena o sa batla o batle ho bua le nna o sa mpatla.
And there will be a fight.
Ba ba
If
teng,
you-
a bang.
There will be a fight in your home because I will kill you as you are saying you no longer love me."
E tla ba teng ntwa mane ha e le hobane ke tla o bolaya jwalo ka ha o ba sa mpatla.
Because they were scared. In fact, she's saying that they got in the car. The deceased was scared now of driving.
Hobane ba tshohile ba ile ba kena koloing mane.
And they asked, they went to Capitec Bank
Ba
to
tsamaya
ask
ba
for
ya mane
someone
Capitec.
who was to assist them in driving the car.
Ba ya mane Capitec ba ile ba ile sheba mofuta wa thusetsa bakganni ba koloi.
Ultimately, they slept at Area C.
Qetellong ba ile ba robala Area C.
But even at night, the accused continued making phone calls demanding to speak to the deceased.
Le bosiu mosuwa o ile a nna tswela pele a founela mofu enwa a batla ho bua le yena ka ntlha gang.
And when Ms. Ndoni answered the phone, in fact, when the deceased could not answer the phone, or maybe her phone was now off, Ms. Ndoni answered her phone, and the accused person again threatened to kill Ms. Ndoni.
Ka nako eo, o ne
Sorry,
ntse a-
threatened to kill the deceased.
Yes.
Yes.
Ka nako eo mosuwa o ne a ntse a letsa ho fihlela mofu a kwala mohala wa hae. Ya ba jwale o sa letsetsa mohala wa Mme Ntoni. Mane mohala wa Mme Ntoni a nne a etsa diketso tsa ho bolaya mofu.
So Ms. Ndoni is saying that in the morning now, as they were preparing to go to work, the deceased drove her to her place so that she could prepare to go to work, as they were working at the same school.
Jwale hoseng ha ba ntse ba lokisetsa ho ya mosebetsing, mofu o ile a kganna Mme Ntoni, a mo kgannela koloi, ba ya ha Mme Ntoni, moo a dulang Mme Ntoni, ba tlo lokisetsa ho ya mosebetsing.
Ms. Ndoni alighted from the car, got inside her room. Hardly 5 minutes, she heard